I want you to imagine just for a second a legal battle with $150 billion on the line.
Which is just a staggering amount of money.
Right. It's massive. And picture the world's most famous billionaire acting as the plaintiff. He steps into this California courtroom fully prepared to wage a war that could literally leave the future of artificial intelligence hanging in the balance.
Yeah, I mean, the media has spent months framing this as the trial of the century.
Exactly. The stakes are completely existential.
Yeah.
And then I want you to imagine a jury looking at the core arguments and, well, essentially tossing the entire case out of court in less time than it takes you to sit down and watch a movie.
It is honestly the ultimate anticlimax. The whole industry spent this immense amount of energy preparing for a drawn-out, precedent-setting clash over the soul of AI.
Yeah.
And the legal system just looked at its watch, cited a procedural deadline, and shut the whole thing down.
And that is exactly the reality we woke up to today. Because today is Monday, May 18, 2026, and a truly pivotal verdict has just been reached in the tech world.
It's a huge deal.
It totally is. And we are pulling our insights for this discussion from a very sharp analysis piece by KNN Paul Kanda over at Yahoo News, as well as a pretty revealing report from Forbes Japan.
Yeah, and both of those sources are essentially painting a picture of a tech landscape that is fundamentally shifting its structural foundation as we speak, like right now.
Right. So our mission for this deep dive is to unpack the sudden, shocking climax of Elon Musk's lawsuit against OpenAI. We need to look at the mechanics of, why the jury ruled the way they did.
Which is fascinating in itself.
It is, and perhaps more crucially, how this seemingly straightforward legal decision triggers a multi-billion-dollar ripple effect for the upcoming IPOs of the world's biggest tech companies. Okay, let's unpack this.
I think the sheer speed of this verdict is really where the story has to begin.
Yeah, let's talk about that.
So we are talking about the Northern District Court of California over in Oakland. The jury receives the case, they go into deliberation, and they emerge in, less than 2 hours.
2 hours to decide the fate of a $150 billion claim. I mean, that implies they didn't even have to debate the merits of the actual allegations, right?
They didn't. They didn't at all. The verdict they returned was completely unanimous. They said OpenAI is not liable for Musk's claims of breach of charitable trust and unjust enrichment.
Wow.
But the reasoning behind that speed is the critical part. You might naturally assume that a case involving the original charitable mission of an AI company would force a jury into days, maybe weeks, of complex ideological debate.
Right, like debating the ethics of open source technology versus corporate secrecy. You'd think they were in there wrestling with philosophical questions about what it means to build AI for humanity.
Exactly. But from what the sources highlight, the core reason they tossed it out was incredibly mundane.
It wasn't philosophy at all.
No, it was just the statute of limitations. The jury looked at the historical timeline of OpenAI and simply decided that the plaintiff waited way too long to launch this attack.
Which is wild. So the timeline is basically the linchpin of this whole legal failure, right? Let's rewind.
Yeah, let's look at the dates.
So in the founding era, Elon Musk was heavily involved. But he originally left the OpenAI board of directors back in 2018.
Right. And then in 2019, OpenAI executes this massive structural pivot. They established their capped profit arm,
Which fundamentally changed their corporate DNA. They went from a pure nonprofit research lab into an entity that could take on billions in outside investment.
Exactly. Which is, when Microsoft enters the picture in a major way.
Right. Yet, despite that foundational shift happening all the way back in 2019, Musk waited until August 2024 to actually file this lawsuit, claiming a breach of trust.
Yeah, it's a 5-year gap between the structural change and the legal action. And in corporate law, that is an absolute eternity.
Thinking about that gap, it reminds me of someone quitting a garage band.
Oh, I like that.
Yeah, imagine you are the lead guitarist in a band. You guys have this specific indie sound, but you get frustrated with the direction, you just quit.
Right, you walk away.
The band keeps playing without you. 5 years go by, they change their sound, they sign to a major label, they put out a pop record, and suddenly they are selling out global stadiums.
And making millions.
Exactly, making millions. And then 5 years later, you show up with a lawyer trying to sue them for abandoning their original indie roots after you'd already walked away.
That analogy holds up surprisingly well to the legal mechanics here. The jury recognized that exact dynamic. The plaintiff was intimately involved in the early days. What's fascinating here is that he was sitting in a position where he knew all about those capital structure changes when they were being discussed.
Because he was there, or at least he was tapped into it.
Right. He knew about it in 2019. The shift to a capped profit model wasn't a secret. It was a highly publicized maneuver that was, frankly, necessary to afford the computing power required to build these large language models.
So he had a front row seat to the pivot, meaning he could have sued in 2019.
Precisely. By waiting until after ChatGPT became this undeniable global phenomenon in late 2022 and 2023, I mean, after the garage band had already sold out the stadium, it entirely undermined the credibility of his legal claim.
Yeah, that makes sense.
In the eyes of the law, you don't get to observe a company becoming incredibly successful over half a decade before deciding you suddenly have a moral and legal objection to how they structured their business.
Right, the statute of limitations exists specifically to prevent that kind of retroactive ambush.
Exactly. That delay was simply fatal to the case.
Which forces us to look at the actual stakes of this lawsuit, because this was never just about a billionaire feeling slighted over philosophical differences. The demands in this lawsuit were staggering.
No, totally. He wasn't seeking a symbolic victory or some sort of apology tour. The primary demand was $150 billion in damages.
Which is just an unfathomable number.
And beyond the financial penalty, he demanded the outright firing of OpenAI's CEO, Sam Altman, and its president, Greg Brockman.
And if decapitating the leadership wasn't enough, he wanted a legal injunction to completely stop the privatization of OpenAI's technology.
Right.
He essentially wanted a court order to forcibly rewind the company back to its nonprofit open source roots, literally making all of their proprietary research free to the public.
Which, if you understand how corporate finance and venture capital actually function, is essentially throwing a massive wrench into the gears of a machine just as it's trying to reach escape velocity.
Exactly.
And that brings us to the real underlying motive the sources point to, the battle of the IPOs. We have to look at a quote from Wedbush analyst Dan Ives, who was highlighted in the Yahoo News piece.
What did he say?
Ives points out that while Sam Altman's personal image might have taken a temporary PR hit from all the drama, this legal win is actually a formidable tailwind for OpenAI.
I want to break down why that is, because it gets to the heart of how public markets operate. If OpenAI had lost this case, or honestly, even if they hadn't lost, but simply entered a drawn-out, multi-year legal swamp with discovery and appeals, their plans for an initial public offering would have been completely frozen.
Yeah, the mechanism there is the S-1 filing.
Right.
An IPO requires a company to open its books to the public market and list all of its potential risks. Institutional investors think pension funds, large asset managers, they have fiduciary booties.
They can't just gamble.
Exactly. If your company's biggest listed risk is an active lawsuit that might force you to fire your executive team, pay out $150 billion, and give away your core product for free, the institutional capital simply walks away.
The IPO freezes completely. Yeah. And that freeze wouldn't just hurt Altman, it hurts deeply invested shareholders like Microsoft and SoftBank who are, actively looking for liquidity.
Yeah, a pending lawsuit of that magnitude creates a toxic level of uncertainty.
Okay, so a drawn-out lawsuit freezes the OpenAI IPO.
Mm-hmm.
But here is the piece of the puzzle that is genuinely fascinating when you look at the calendar. Elon Musk's SpaceX has its own highly anticipated IPO plan for June 12, 2026.
Yeah.
That is just weeks away from this verdict.
The timing is, well, it's impossible to ignore when you overlay the corporate calendars.
It feels like way more than a coincidence. You have two of the most heavily anticipated tech IPOs of the decade preparing to hit the market. And one side launches an aggressive legal strike that, if successful, would completely paralyze the other side's ability to go public.
Or even if it just prolonged it through endless appeals. And this is exactly why the sources view this not as a noble crusade for AI for humanity, but as a highly tactical, worldly business battle.
A stall tactic.
Right. If you look at the mechanics of the stock market, there is a finite pool of institutional capital ready to be deployed into mega-cap tech IPOs at any given time. By dropping this legal anvil on OpenAI in 2024, you create a chilling effect.
Right. Investors pull back from OpenAI out of fear.
Yeah, exactly. Which beautifully clears the runway for a rival IPO like SpaceX to dominate the market's attention and absorb that capital without competition.
It's a game of capitalist chess, where the opening move is disguised as a fight for pure justice.
That brings us to the concept of position talk, which the Yahoo News analysis leans into heavily to explain the jury's skepticism.
We should define that, because if this lawsuit was essentially a tactical stall to clear the IPO runway, it was his own business ventures that basically gave the game away to the courtroom.
Right. So position talk is a term often used in finance. It refers to someone talking up or talking down an asset or a competitor simply because it benefits their own financial position rather than offering an objective truth.
Got it.
While the plaintiff was in court demanding that OpenAI return to its nonprofit roots, we have to look at what he is actively doing in his own backyard. He currently runs a highly powerful, explicitly for-profit AI company called xAI.
Which operates directly under the SpaceX umbrella.
Exactly.
And xAI is developing Grok, which is a foundation model designed to be a direct, head-to-head competitor to ChatGPT. And they certainly aren't building Grok as a charity.
No, not at all.
They have raised immense amounts of private capital specifically to achieve commercial success and capture market share.
The contradiction is glaring. You have him fiercely criticizing Sam Altman on X, formerly Twitter, accusing him of stealing a charity to line his pockets. But as the head of his own profit-seeking AI startup, raising billions from private investors to build proprietary models, our sources point out that this criticism acted as a boomerang.
It flew right back and pierced his own legal argument in front of the jury.
Yep, it undermined everything.
Here's where it gets really interesting, though. I want to push back on this purely cynical interpretation for a second.
Okay, let's hear it.
Let's play devil's advocate based on the timeline.
Hmm.
Is it possible that he did genuinely care about the nonprofit mission back in 2018? Like, perhaps he really believed AI should be a collaborative, charitable endeavor? But when OpenAI pivoted, partnered with Microsoft, and essentially fired the starting gun on the commercial AI arms race, he felt structurally forced to adopt the for-profit model with xAI later, just to have enough capital to compete.
I didn't want to play this dirty game, but now that you forced my hand, I have to play to win mentality.
Exactly.
It's a very fair point to raise, and psychologically that might very well be how he internalizes his own actions. He may view xAI as a necessary counterweight, but if we look at this impartially, based on the reality of the courtroom and the analysis in the text, his internal feelings or retroactive justifications don't actually matter to the jury.
Because they can only judge the actions in the timeline.
Correct. It's about the optics to the market and the optics to the jury. It looked exactly like position talk. To the juror, this presented as a latecomer in the AI race trying to use the legal system to drag down the frontrunner. Because he is running a massive for-profit competitor, there was simply no room for the jury to see pure justice in his claims. They looked at the board and saw a businessman trying to kneecap his biggest rival ahead of a liquidity event.
So he couldn't win the battle in the courtroom to stall his rival. The jury shut that strategy down in under 2 hours. But, based on everything we know about this industry, if a legal strategy fails, you don't just fold up your tent.
No, you pivot.
How is he fighting them in the actual market now that the courtroom door is closed?
This is where the story shifts from the courtroom back to the server rooms. If you can't stall them with lawyers and injunctions, you have to beat them with infrastructure and compute.
And this connects to a major new strategic alliance. The Forbes Japan report highlights that a significant industry realignment is happening right now, operating on the classic rule, the enemy of my enemy is my friend.
Oh, absolutely.
On May 6, 2026, literally just days before this verdict came down, SpaceX and Anthropic signed a major partnership agreement.
And for context, for anyone who doesn't track this daily, Anthropic is widely considered OpenAI's most formidable direct rival in the foundation model space. They build the Claude models.
Right, and this new deal isn't just like a corporate handshake or a co-marketing agreement. It gives Anthropic full and exclusive access to something called Colossus One. And we need to explain what that actually means because it provides Anthropic with unparalleled GPU and compute power.
Yeah, let's break down the mechanics of compute because it is the actual currency of the AI industry.
It's everything.
In the world of artificial intelligence, the bottleneck isn't always having the smartest engineers or the best algorithms. The bottleneck is physical silicon and electricity. It's the massive arrays of graphics processing units, GPUs, required to train these frontier models.
You need tens of thousands of these chips running hot 24/7.
Exactly, sucking up municipal-level power grids just to teach the AI how to think.
So it's an incredibly capital-intensive physical process.
Very much so. Colossus One is a sovereign-scale supercomputing cluster. By giving Anthropic exclusive access to it, SpaceX is essentially arming OpenAI's biggest competitor with the heavy artillery they need to fight a ground war in the market.
Oh.
The attempt to use a legal injunction to stall OpenAI failed, so the new strategy is raw computing power and strategic alliances.
So what does this all mean?
If we connect this to the bigger picture, it is an incredible pivot. It's an acknowledgement that the legal avenue is permanently closed. The fight has officially moved to infrastructure, scale, and market share.
He couldn't stop OpenAI's IPO with a lawsuit, so he is directly empowering their biggest rival with the physical infrastructure they need right before he takes his own company public.
Yeah, the legal chess game is over and the physical arms race has leveled up.
Which brings us to the reality of where we stand today. Let's bring this all together for you. OpenAI has officially secured its ticket to an IPO. The $150 billion dark cloud has been lifted from their S-1 filing.
They are clear for takeoff.
They are now going to accelerate their development by tapping into unprecedented amounts of public capital. But, as our Yahoo News source points out quite starkly, this means OpenAI is permanently and irreversibly dropping the dream of pure human contribution.
The transformation from a research lab to a publicly traded corporation is complete. There is no going back.
The source actually calls them a cold-hearted capitalist monster now, noting that their decisions will be driven entirely by quarterly earnings, fiduciary duties to shareholders, and stock prices.
Yeah.
The nonprofit shield and all the idealistic rhetoric that came with it is gone forever.
And as for the plaintiff, he does plan to appeal the decision, but as the analysis notes, it is going to be an incredibly uphill battle.
The statute of limitations is a very hard legal wall to climb over.
Especially when the underlying facts of the timeline aren't in dispute. Everyone agrees on what happened in 2019.
Right. It's deeply ironic. The source concludes that by launching this delayed surprise attack, the genius who dreams of space really only managed to prove his rival's immense value to the market. He gave OpenAI a stress test, they passed it with flying colors, and it completely solidified their path to going public.
He tried, but he simply couldn't rewind the quartz clock. The broken clock stays broken.
And I think this is a vital takeaway for you listening. The AI tools that you use every single day, whether you are using ChatGPT to draft an email, or Grok to search for news, or Claude from Anthropic to analyze a document, these are no longer just fascinating little science experiments cooked up in an idealistic nonprofit lab.
Not anymore.
They're the centerpieces of a brutal, legally complex, multi-billion-dollar game of capitalist chess.
The era of the AI charity is definitively over. We are firmly entrenched in the era of the AI megacorporation.
Which leaves us with a pretty heavy question to ponder as we wrap up. If the largest AI companies in the world are now legally, structurally, and financially bound to prioritize quarterly profits and shareholder returns over their original charitable, human-centric missions,
Right.
what mechanism is actually left to ensure these incredibly powerful systems remain safe for humanity? When the indie garage band becomes a massive profit-driven corporate machine, who is actually checking the sound? Who holds the reins when the nonprofit dream officially dies? Something to think about the next time you type a prompt into that little chat box.